Hi, this is Emily Sumner. I am so sorry we're starting late. There was a technical difficulty with getting this started. But we wanted to talk to everyone today about what to do if you were not selected in the H-1B lottery. The H-1B lottery was conducted this recently, and USCIS announced just yesterday that they have finished conducting the H-1B lottery. All the selections are done. There were a lot of registrants. USCIS has not published yet the exact numbers as to how many registrants they had this year, but they have had a lot of registrants in years past, and I would imagine the same is true for this particular year. We'll certainly publish that information when it's available, but in general, a person's chances of being selected in the lottery are about 1 in 3 or 1 in 4, maybe depending on how many people have registered for the H-1B lottery. So what are you going to do if you were not selected in the H-1B lottery? The first thing to consider is that what your current immigration status is. So if you are not in the United States, then this won't apply to you. But if you are in the United States, consider what your current immigration status is. If you're in the United States on a student visa, for example, then you may be able to continue with that student visa. Sometimes your OPT will be valid for another year, for example, and you may be able to continue working and stay in the United States working on OPT. That would be great. However, that may not be the situation. If you are in the United States on a student visa, check to see if you're eligible for the STEM OPT. The STEM OPT extension is available to people who are in certain fields in the United States, but not everyone. So check with your DSO to see if you're eligible for a STEM extension, which could give you an additional 2 years of OPT. Depending on your coursework, you may be eligible for something called CPT, which is curricular practical training. You do have to be in the United States studying on F1 status, and you have to be continuing your degree. So you may have to enroll in another degree program. That's not always the best option. Sometimes CPT is not appropriate. CPT is designed to be used in situations where the coursework that a person is taking requires in-person experience, like an internship, for example. So that may or may not be appropriate for you. You may be able to continue studying in the United States at a different degree level. So not the ideal situation, you may not be able to work, but that may be able to allow you to stay in the United States and try again, hopefully next year, for the H-1B lottery. I'm gonna move on now to other visa classifications, other options for individuals who were not selected in the H-1B lottery. And if you all have any questions, please put those in the comments, and I'm happy to try to answer those questions if I can as we go along. So other visa classifications, for almost every letter of the alphabet, there's a different visa classification. And then there's subclassifications within those visa classifications. Every visa classification has a very specific purpose, duration, and requirements. A lot of these visa classifications are specific to citizens from different countries. So in other words, they are based on treaties. So that's something to look into. It probably or may not be an option for you. You know, if you've gone with the H-1B route, you've probably gone through that analysis with me or another immigration attorney and determined that the H-1B was your best bet. But I want everyone to be aware of this because sometimes a person will not select another category that they may be eligible for, either because they don't know it exists, or maybe there were a couple drawbacks for that category, but since they weren't selected in the H-1B lottery, they want to go explore that category instead. So some of those categories that are treaty-based are the TN. The TN is for citizens of Canada and Mexico. The E3 is for citizens of Australia and Singapore. The H-1B1 is for citizens of Chile. Sorry, the E3 is for citizens of Australia only. The H-1B1 is for citizens of Chile and Singapore. So if any of those apply, let us know. We're happy to help you walk through those particular options for you. Again, those depend on their country of citizenship, not birth, but citizenship. Another option may be the E2 visa. Again, that's based on treaty. The United States has a treaty with different countries around the world that allow a person to work in the United States, to invest in a company in the United States. And I'm not talking about the EB5 category. I'm talking instead, which is the EB5 category is the investment visa for a green card. I'm not talking about that. Instead, I'm talking about the E2 category, which is for investing in an investor visa, investing in the United States. So if you wanted to start a company here or invest in a company that already exists in the United States, that could be a possibility. Another possibility, maybe, that is not a country condition, there's no condition on which country you're from, is the L. The L is for citizens or individuals who are working for companies overseas and they want to be transferred to the U.S. entity that's related to that entity overseas. So there has to be a specific corporate relationship. The U.S. entity has to be a parent, subsidiary, affiliate. There are any number of qualifying corporate relationships. And the person in the U.S. would be transferred as a specialized knowledge worker, that's L-1B, or an executive or manager, that's L-1A. That might be a possibility. You have to have worked for that entity overseas for at least one of the past 3 years. So if you're in the U.S. studying on F1, that's probably not the situation. But again, we want to explore all the possibilities. And then finally, another non-immigrant classification, and I'm just looking at my list to make sure that I'm catching them all here, or at least the major ones, is the J. The J is used for many different reasons. It's to facilitate intracultural exchange. So au pairs come on the J, long-term and short-term research scholars can come on the J. It can also be used for interns and trainees. So if you have recently graduated from university, that might be a possibility. The disadvantage of the J1 is it is for a shorter duration than the H-1B. It's not dual intent. It's not designed for you to hold the J1 and also apply for the green card at the same time. And there are certain instances in which you may be subject to the 2-year home residency requirement. That means you may have to go back to your home country at the end of your J1 stay for a period of 2 years before you're able to come to the United States in a different visa classification or start the green card process here in the United States. So those are the major non-immigrant visa classifications. Like I said, there's a different visa classification for almost every letter of the alphabet. So there are a few others out there that you may want to explore, and we're happy to have individual conversations with anyone who's interested. We're setting up consultations for next week for anyone who was not selected in the lottery and wants to have a more detailed conversation about your specific situation. Next, we're going to turn to the green card options. This is very common for an individual who has not been selected in the H-1B lottery to, instead of pursuing the H-1B, or maybe they pursue it again next year, but at the same time to start the employment-based green card process. This can be done for an individual who's overseas. So if you are overseas, you don't necessarily, or anyone, regardless of where you are, you don't necessarily have to be working in the United States for the particular company that's sponsoring you. You can be working overseas, or you can be in the US in a different classification like F1, but it is possible to start the employment-based green card process while you're here. It could be that you're on F1 and let's say you have a STEM OPT extension and you're able to keep working on the STEM OPT while that green card is in process. I will say that starting the green card process itself does not allow you to remain in the United States. So if you're in the United States, let's say an F1 status, or maybe your spouse is in the United States on an H-1B and you're in H-4 status, starting the green card process itself will not allow you to remain in the United States, and it will not allow you to work in the United States. So you do have to have another strategy for that if you want to stay in the United States while the green card process is going on. The green card process can take a number of years. And I will say that if you were born in India or China, there's a very long wait for a green card. That has to do with restrictions on the number of green cards available and numerical limitations per country, more than kind of not the topic of today's talk, so we won't get into that. But just know that if you are born in China or India, that's probably not the best strategy for you right now. That may be something you want to pursue down the road, but it's not going to be a shorter term fix for the situation if you were not selected in the H-1B lottery. However, if you were born in a different country that's not China or India, and we're talking about country of birth, not country of citizenship. So if you were born in a different country, then you may be able to start the green card process now, even though you were not selected in the H-1B lottery. We've had lots of clients, plenty of clients go straight from F1, for example, to the green card. The process at which you can remain in the United States in H1, remain in the United States because by virtue of having your green card filed is once you file the I-485. It's going to take a bit of time. I would say at least 18 to 24 months until you're able to get to that point. Maybe that's a little long, maybe 18 months. Until you're able to get to that point, and that's always subject to change and very case specific. But once you have filed the I-485, then you are in what's called a period of stay authorized by the Attorney General. That still doesn't mean that you have permission to work in the United States. You have to wait for the work permit to be approved, and we submit that at the same time that we submit the I-485. However, that's a possibility. Like I said, we've done that for plenty of clients, and it is a viable strategy if you were not born in China or India. And then finally, think about other ways that you may be able to stay in the United States. So for example, I have had individuals over the years who were either married to US citizens or green card holders, or they were engaged. And our client wanted to pursue H-1B because they wanted to go through the immigration process on their own. But then once they found out they weren't selected in the lottery, they thought, okay, this is a viable option. You have to get married for love or for other valid reasons. You can't get married, just for immigration purposes. That's immigration fraud, and we definitely want to stay away from that. But if you're in a relationship, a valid relationship, and you're planning to get married anyway, that could be something that you look into pursuing maybe sooner than you had planned otherwise. That could be a possibility. Likewise, if your spouse is in the United States, let's look at their immigration status and their immigration options. Let's say that they are on F1 right now and they're going to pursue a postdoc, for example, when they graduate. They could go to J1 status as a postdoc. J2 spouses are work authorized, and J2s are the dependents. So you want to really analyze the options that your spouse has as well to see if that may benefit you in addition. And that's an analysis that we can make, on a case-by-case basis. Everybody's situation is different. So I am going to post in the comments, if we have not already, a link to a blog post that we have on this particular topic, so that that's available to you all. If you have any questions, put them in the chat. I'm going to stay on for a couple more minutes, and I'm happy to try to answer any questions that you may have. But I hope that you have found this information helpful. Again, we'll put that link to the blog post in the comments to this particular video so you have access to that. And like I said, if you want to speak to us in more detail about your particular situation, we're happy to set up a consultation for you. We're setting up consultations, 30-minute consultations. The consultation fee is $100, and that would be set up for next week. So we're happy to talk to you about that. One individual asked about the O1 visa. Yes, absolutely. So the O1 visa is used for individuals who are, I don't like to use the word aliens. I don't like that word in general, except for people who are, individuals, creatures from outer space. But anyway, that's the word in the statute and the regulations, aliens of extraordinary ability or foreign nationals of extraordinary ability. So that can be in the sciences and business and the arts. There's the O1B and the O1A, depending on which particular field your extraordinary abilities are in. you may hear my puppy barking in the background here. She wants to say hello. But the O1 is used for foreign nationals of extraordinary ability. It is similar to the green card based category, the EB1A, which is for foreign nationals of extraordinary ability, but it's easier in general than the EB1A to have approved. The standard is a little bit lower. There are certain criteria that you have to meet, and you do have to have an employer who's willing to sponsor you, or you have to have an agent in the United States. It is possible to file an O1 with an agent depending on, if you're an artist, for example, and you're going to be performing at different venues, it is possible to do that. So that's a possibility. One person asked, would an EB3 be a viable option? Absolutely. The EB3 is, and that is a category. There are different preference categories within the employment-based categories. There's EB1A, or EB1, rather, and then different classifications there, and then EB2, EB3, EB4, EB5. So EB3 refers to one of the employment-based categories, and yes, that absolutely is an option. That's what I was referring to a few minutes ago when I was saying you could, in theory, start the employment-based process, green card process, rather. That's something that the employer has to sponsor, obviously, and it is going to take some time, but it is a viable option. Like I said, we've had clients go through that before, so it's absolutely a viable option. The timelines can be challenging, but it's doable. Depending on your situation, you may have to continue your studies. We have one client now who wasn't selected last year, fortunately was not selected this year either, but they were... they re-registered in school. They started a new degree program and were well into the green card process, and he'll have his green card probably sooner than he otherwise would if he were selected in the H-1B lottery. So that's a silver lining of this. Another person asks, and keep posting your questions, I'm happy to keep going here. What are the deadlines for the next rounds of this year's H-1B selection process? So there are not deadlines, and thank you for bringing that up. I have meant to mention that there are probably going to be multiple rounds of selections. So one of the reasons that we have so many people who have registered in the H-1B lottery is because it's relatively easy to do. There's a $10 registration fee. If you go through a lawyer, you have to pay the legal fee, but even that is relatively low compared to what the overall cost of filing an H-1B petition is. So it's pretty easy to do, and lots of people in the United States will register through different employers, multiple different employers, to increase their chances. I don't like that people do this. I'm not a foreign national, so I can't, I'm not in your shoes. I can't speak to that. But I don't like it because it takes up slots that otherwise would go to a different person. So in other words, if person A registers through 10 different employers and is selected with 3 of them, then they're taking up slots that could have gone to somebody else. Right now, there's not a restriction against that. There is a restriction against an employer filing for multiple registrations for the same employee, but not for an individual, for a national, registering through multiple employers. Anyway, that's the reason that we have so many, and just because there's, a labor shortage, and foreign nationals are awesome, and we want them to work in the United States. Anyway, the process is that USCIS has conducted this first round of selections, and that's complete as of yesterday. USCIS will conduct the round. They will see, we have 90 days to file. So anybody who was selected in the H-1B lottery, you have 90 days to file the H-1B petition. So you have to file between April 1st and June 30th. In July, USCIS will assess how many petitions have we actually received. We sent these notices to 85,000 people. Do we have 85,000 petitions to use up all of the numbers that are available? If they do not, and it's likely that they won't, then they will conduct another round of the H-1B lottery selection. So that happened in July of last year. And actually, our wonderful paralegal Namrata gave us the dates of that recently. I think it was the end of July. But anyway, yes, it was July 28th last year. It doesn't mean it's going to be that exact date again this year, but it's going to be around that time frame. So it's possible that if you were not selected now, it's possible that you would be selected later this summer. And that's not something you have to do anything. You don't have to re-register. There are no deadlines for you. There are no deadlines for USCIS. We don't know exactly when they're going to announce the second round, but they will. They'll send an email and they will notify, of course, anyone who is selected, but they'll also send a general email. If you're not registered for USCIS emails, you can go to their website and register for emails, and you can select the different topics that you might be interested in. So they will let us know in probably July. And then again, once you're selected, you have 90 days to file. This past year, in 2021, we actually had a third round of lottery selections because they still didn't have enough people who had filed. Again, because people register for through multiple employers, or they may change their mind and, go back home, unfortunately, or they may start the green card process, or different reasons, plans change. And they don't file the H-1B petition. So last year, that third round was held in November 19th, just before Thanksgiving. And then again, we had 90 days to file. In fact, we recently in February filed our last H-1B petition from that third selection, and then it was recently approved. So that is a possibility to be selected. And again, you don't have to do anything. You don't have to re-register. Just keep an eye on your email so that you're aware if you are selected in those second or third rounds. Again, I'm happy to answer any questions. We will also put in the comments a link to a chart that we have. It's a table of the most commonly used non-immigrant visa categories that could be helpful for you as you analyze your options. So it lists the different visa classifications, the general requirements, general timeframes, general restrictions, things like that. As with all of this, this is not legal advice. It's for information only, but it's at least something to get you started to help educate you about what your options may be. Well, if you have other questions, feel free to send us a message either through Facebook or to info@sumnerimmigration.com. Or you can set up a consultation with us. Like I said, we're having consultations next week for $100 30-minute consultation slots to talk about what your options might be and help you get started on the path to immigration success in the United States. I hope you found this helpful. Please feel free to share this video with anyone else who might find it helpful. And until next time, I'm Emily Sumner with Sumner Immigration Law. Bye.